Welcome to this strategic briefing on navigating the ghost litigation audit. We will examine the implications of the 2025 NZSC 192 decision and the upcoming 2026 Procedural Framework. The core conflict involved the NZ Independent Community Pharmacy Group challenging District Health Board, or DHB, decisions granting pharmacy licenses inside large supermarkets. The issue was complicated by one pharmacy ceasing operation, introducing a mootness risk. The Supreme Court dismissed the appeal and awarded cost sanctions against the applicant, penalizing them for pursuing, quote, dead law. Pae Ora was awarded higher costs for filing more extensive submissions. This case highlights the danger of ghost litigation, fighting over repealed laws. The court refused to hear the appeal, as the law governing the original dispute had fundamentally changed. The legislative fault line shows the shift from the legacy era of DHBs and the repealed NZ Public Health and Disability Act 2000 to the 2026 context under the Pae Ora Act 2022 and Te Whatu Ora. The jurisdictional gatekeeping process led to dismissal, since the proceeding only sought declaratory orders under a repealed act and was not deemed to be in the, quote, interests of justice. It failed at Gate 3. The GEEM ethical audit shows high scores for legality, integrity, and legal ethics, prioritizing systemic efficiency. The court prioritized current legislative relevance over historical right versus wrong. The dismissal of transitional cases for mootness created a precedent vacuum. This means past administrative mistakes from the DHB era cannot establish binding case law, providing a clean slate for the Crown under Pae Ora. Navigating political crosswinds reveals a tension between protecting local governance and centralizing for efficiency. Litigating against big retail must appeal to rural voters protecting local chemists, not just legal theory. The legacy claim concerning Maori health equity faces a narrow path. The 2025 Amendment Bill removes the requirement for Te Whatu Ora to maintain systems for understanding Matauranga Maori, drastically limiting future Te Tiriti challenges. The 2026 procedural engine mandates a shift from the legacy architecture's expansive discovery to the reformed architecture's overriding objective of proportionality. The process is now evidence first, with mandatory judicial issues conferences. Our AI risk scanner detects ghost vulnerabilities based on keywords related to the repealed 2000 Act. Claims seeking declaratory orders without private rights or operational status risk, high dismissal probability, and adverse cost sanctions. The recommended mitigation strategy is the strategic walkaway. This involves immediate discontinuance to preempt cost awards, citing the NZSC precedent, and proposing a costs-neutral walkaway in a clean break clause. The strategic pivot requires stopping the fight over legacy DHB processes. The new target must be a test case against the 2025 timely access criteria under Pae Ora, using today's law to protect local health hubs. The Supreme Court's dismissal confirms historical correction is dead. Future survival requires abandoning ghost litigation and fighting entirely within the boundaries of the Pae Ora framework. It is time to adapt to the new game.